let me say a bit about family law. If you're on this site, you're wondering about what you need to do to get rolling and get started with family law. Family law in the old days wasn't quite as complicated as it is today. In the past, you filled out a few forms, you went down to the courthouse. There wasn't a whole lot of discovery. More often, if there were issues, the issues were related to alimony and property, not as much perhaps when it came to children. Now, today, the family law files have grown. They are rather thick, and there's a lot of stuff that's required. And I'm going to go over that with you. So, this segment is about if you're looking to file for divorce, and I'm going to talk about separation. How do you start? Where do you go? What's going to be involved? Well, first is, for a number of people, it is probably a good idea to begin with a separation agreement. Now, what's a separation agreement? Separation agreement is a document which identifies what everyone's rights and obligations are on a temporary basis. In the context of a case that's filed, it would be equivalent to what we call temporary needs. So you're specifying what everyone is going to do, and it gives you also an opportunity to remove a lot of the pressure and to kind of stabilize the house. More often than not, as people get ready to file, the feeling is kind of like this. I just want the pain to stop. I just want the arguing to stop. I just want the tension to stop. I just want the drama to stop, whatever it is. So you obtain initially some relief. The problem is, oftentimes people are trying to work on the divorce, but they don't have a plan. So the separation agreement is what I call a game plan. It specifies what everyone is going to do. So for example, it may say, one party has the house, maybe you both are going to live in there. What are you going to do with the kids? What the time sharing is going to be? Who's going to pay what bills? What about counseling? What about drug and alcohol treatment? Attendance at different functions? How are we going to manage the debts, the affairs, use the cars? If you own a business together, how are we going to work? And I recommend that we take advantage of that because it's a very useful tool. People often ask me, I'm not sure it's going to work out. Wasn't this a waste of time? No, it's not. Because if you were able to reduce tension and you were able to get many of the issues worked out, it makes it easier to resolve the case as a whole later. So there's always the possibility of a separation agreement. What else do we have to consider? Well, we have to consider first safety. When people come in with me for initial consultation, I'll always address what I call the 3 S's. The 3 S's are safety, security, stability. We're concerned with stability, financial, there's housing, there's food, the bills are being taken care of and the children are taken care of, and there's money for each of the parties to live. Safety, domestic violence. Domestic violence. Are there issues regarding personal safety that need to be addressed? Whether someone needs to get some sort of a injunction for protection, or in some instances, someone needs to obtain complete relief, including ownership or what we call exclusive use and ownership of the home, plus sole parental in some circumstances, and instead of shared, a number of things. So we look at all of that. Security. What is security? This may sound, perhaps, a little bit different. Security means that this doesn't affect you in such a way that you lose your job, that you lose things. So for example, security, making sure that the ship runs on time and that you're able to function, go to work, and that you don't lose your job. We often see it where it's not handled right and everything gets out of whack. All the emotional stuff, the financial stuff. Then you start getting to work late or you have problems at work. Next thing you know, you're terminated, you're fired, and now the situation has gotten even worse. So safety, security, stability. Now, what I do is, and what I do with my clients is I have this book. And this booklet becomes your Bible as you go through divorce. If I'm retained as your counsel after we have our initial consultation, and I'm retained, you're going to come back for what I call a discovery conference. During the discovery conference, I have a number of documents which you're going to need to provide. Now, what are those documents? Well, I have everything laid out in these materials. First is, I have a confidential questionnaire that I need for you to fill out, which gives me information about you, about your family, and about whatever some of the issues are, including you ranking and telling me what's most important and what you're trying to accomplish. From there, I have the retainer letter and some of the important things that you're going to need to fill out and take care of right away, all for you in this book that you can carry around. This is yours to keep. The Family Law Financial Affidavit, one of the most important documents that you're going to work with. So at the Discovery Conference, you're going to, prior to arriving, you're going to have worked on and filled out your financial affidavit and your questionnaire. Then, also important, I have in here all of the things that you need to provide, including, by the way, instructions on filling out the financial affidavit, and I have information on the Florida Child Support explaining to you what all goes into that. Now, I used the word early on about mandatory disclosure. Here it is. These are all the items that have to be provided to the other side within 45 days of filing or being served with the divorce. All of these documents and all of these papers all need to be brought in. I have here on Schedule A, listed another way, all of the documents that need to be provided. So you're going to bring all of these things in, and I will sit down with you, and we will go through together, trying to understand a number of the issues, the facts, what's important to you, understanding your finances, understanding what your needs are. This is Children First and Divorce. If you have children, you're going to be required to enroll in and attend a class called, we call it CFID, Children First and Divorce. In Jacksonville, that's at Hope Haven, and in Fort Myers, they have similar classes that you can take. Some judges allow you to do it online, but more often they want you to go there in person. They have times at night and on Saturday that you can sign up for in order to complete the class. It's also designed to help you learn and understand a little bit more about the child care and what goes on in the context of a divorce. Now, I have the Florida statute in here, and I also have what we call custody interrogatories. Now, at this discovery conference, what we're going to do, after we get all this information together and we come up with our plan, we start to execute that plan. Now, let's say that you have minor children. Well, I'm starting to prepare you for, depending upon what you're thinking in terms of time sharing, how we're going to go about it, what we need to do, what's going to be involved. So, for example, we have a thing called in Jacksonville, the Fourth Judicial Guidelines, which set forth what the minimum guidelines are for the majority time-sharing parent and the minority time-sharing parent. If the parties are looking at something more than that, then, and if there's agreement, then most of the time the judge is going to accept whatever the parties have agreed to, as long as the judge makes a finding that it's in the best interest of the minor children or child. If you're not in agreement and there's going to be a custody battle, then we get into a number of other factors. So, if there is going to be a custody battle, we're going to end up with a number of things. One of those is custody interrogatories. We will serve the other side, and you will likely receive the same, and it's in here, what the custody interrogatories are, what they say, what information they're seeking to obtain. You're likely then also going to have a deposition taken, which is going to be a rather lengthy thing, 6 to 8 hours. And the court has to make a decision, if someone files a motion, whether or not there's going to be a custody evaluator, or what we call a social background investigation. Now, there's a difference between the two. A child custody evaluation is normally done by a licensed mental health counselor or a psychologist or a psychiatrist. A social background investigation can be done by any qualified expert, and that includes an attorney. It frequently includes, most of the time, attorneys, but it can include other people, even a licensed mental health counselor. Should that occur, then you're going to have interrogatories for the parenting plan evaluation. And those are also contained within my materials. So you can read that and you can see what that will entail. Child custody, like relocation,